Welcome, everyone. This is the final week of study for the February 2025 MBE exam. We have done every subject. We did a full week of review, and we're going to finish things off by focusing on the three main facets of preparation, which are the Cram guides, the questionnaire, and practice questions. Today, we're going to focus on the Cram guides. Before we started the recording, we did the spin wheel of life, and we got to see just how smart the class was, and I was really impressed. They're as smart as you could ever imagine. But what I want to focus on is the Cram guide. And you know what's incredible? We can focus on the Cram guide that we made as a class. These points should refresh yourselves because these are points that we did together. So let's talk about them. Contracts. If a party requests reasonable assurances because there's insecurity of inability to pay, and the other party responds with audits and financial statements proving they have money, there's no anticipatory repudiation because assurances were provided. This is the same example that Heather and I talked about. You see the tutor partying and drinking for the Super Bowl victory, and you think he's not going to make it to 7 a.m. You say, hey, Tommy, are you going to make it? And Tommy says, I'll be there. Then there's no anticipatory repudiation. The hierarchy of weight goes express terms, course of dealing, industry, trades, or customs. So just in general, express terms will prevail. That's why we have contracts, right? Like you can contract to be like, yeah, in the course of dealing, tutors get paid $70 an hour. I'm charging 500, because of XYZ. You're going to have to be stuck to 500 because that's the express term of the deal. Some gift promises are enforceable under reliance theory, although the general rule is that gift promises lack consideration are not enforceable. This is a really tough question. It was like the answer A looked good. It was like, yeah, there's no consideration, it's a gift. But D was the best answer, that unless injustice will result, then they'll enforce the gift contract. So the only reason they'll enforce a gift contract is to prevent injustice. Generally, a party must incur the consequence of a unilateral mistake. However, if the non-mistaken party knew the mistaken party mistake and essentially took advantage of them, there's a strong argument for the mistaken party to rescind the contract. So, right, mutual mistake, reformation or rescission is appropriate. Unilateral mistake is not going to be the case unless the mistaken party was taken advantage of. So a good example is, there's a sale for the parcel of land for $100,000, and there's a clerical error made by one party, right? And they make it, $100 more, $500 more, and the other party doesn't notice. Well, the other party didn't notice they made the mistake, and the mistaken party is now paying an extra $100 or whatever. That's going to be part of the final contract because the non-mistaken party didn't know the mistaken party's mistake. Now, if they did and they're like, oh, they messed up, I'm going to get an extra $100, that would be bad faith. So the general rule is the mistaken party will bear the burden of their mistake if it's a unilateral mistake, unless there's bad faith involved. Consequential damages are only recoverable if they're foreseeable at the time the contract is entered into. You have to associate those words, consequential and foreseeable. Those are like peanut butter and jelly. I said this earlier, they go together like lamb and tuna fish, but Eric's not here, so I don't think anyone gets that reference. If there's an offer for prompt shipment, a non-conforming shipment is a simultaneous acceptance and breach unless it's accompanied by a notice of accommodation. So this one is tough for people. But if there is a, delivery can be accepted by prompt shipment, like we need these widgets, and you can accept by prompt shipment, and you send the wrong widgets, that's an acceptance and a breach. Unless you say, hey, we didn't have the blue widgets, but here are the red widgets. Will you take this as an accommodation? That's a counteroffer. But prompt shipment, non-conforming shipment is a breach of the perfect tender. Non-disclosure is a possible grounds for rescission. For example, if a horse trainer knows that his horse is Smarty Jones, but tells the kid the horse is nothing special, this could be grounds for rescission, right? Like the horse trainer is going to buy the horse. He knows the horse is special, and he takes advantage of the kid, right? In contracts, look for good faith to be the overarching principle. Impossibility, a bad storm, for example, during a planned boat trip, would allow for rescission of the contract and entitle a party to recover a deposit and restitution, right? So like A and B make an agreement, B is going to take A out on the boat, and then A pays a deposit to B. Well, now there's a storm and they say no boats are allowed to go out. Well, then in the theory of restitution, A will be able to get the deposit back from B. If you don't remember that, just remember my OG album, Ill-Gotten Gains, Restitution. Restitution is to disgorge ill-gotten gains. The party that received the deposit, well, shit, they're not even going out on the boat anymore. They just get to keep the deposit? Absolutely not. Unless it was this party's fault and they pretty much messed up and now, it's a reasonable, liquidated damages fee. But if they're just keeping it and it's not their fault, bless you, Sean, then, they'll disgorge them and they'll have the deposit returned. If an investigator makes an agreement with the private individual to get paid, if he recovers the painting, this contract is valid despite the pre-existing duty rule that the investigator owed as his job because the duty was owed to a third party. The modern view is that the duty owed to a third party is an exception to the pre-existing duty rule. So this is the concept where I work for, a private investigator company, right? And it's my job to find this piece of art. But the person who hired us, the company hits me up on the side. I was like, yo, if you find that art, bro, I'll give you $1,000, between us. I'm like, bet. So then I find the art, even though it was my job, even though it was a pre-existing duty, the pre-existing duty was to the company, not to that person. So there are two different agreements and you could actually get paid on both of them. That's going to be the exception to the pre-existing duty rule. Another common exception to the pre-existing duty rule is going to be an agreement to pay back a previous debt or a lesser amount of a previous debt, just because we want to enforce that. So if like A owes $500 and now they make an agreement where I'll pay 250 of it, and it's like, well, we already owed 500. That's not new consideration. That new agreement is enforceable without new consideration because the promise to pay back a previously existing debt is a long known exception to the prior consideration rule. A repudiation may be retracted, and this is what me and Heather were talking about, unless the other party has already acted in reasonable reliance on the repudiation. For example, if a seller repudiates an agreement to sell land and the buyer buys on their property, it's too late for the seller to retract the repudiation. Heather and I talked about this. Like, she said, Andrew, you're gonna be here for the session tomorrow? I said, no way, I'm going to the parade. See ya. And then she goes and hires a different tutor. And then I say, sorry, the parade got canceled. I'll be there. It's too late. She already, in reliance, mitigated her losses. The conveyance of a quitclaim deed by itself constitutes consideration, even if the conveyor doubts that it has a right to convey the deed, right? The conveyance of a quitclaim deed by itself constitutes consideration, even if the conveyor doubts that it has a right to convey the deed, meaning that, like, there's no need for additional consideration. If you convey a deed, that by itself is proper consideration. The statement, I don't intend to honor the contract unless I'm legally obligated to, is not anticipatory repudiation because it's not a clear and unequivocal statement of an intent to not honor the obligation of the contract. Going back to Heather and I, the tutoring session, Heather calls me, hey, Andrew, I see you partying in the street celebrating the Super Bowl. Are you going to come to the session tomorrow? I'm not going to do anything I don't have to do. And then I hang up. Not a repudiation because I have to do that. That's my job. We had a like I'm legally obligated to do it. So just because I'm not going to do anything I don't have to do, I have to do that. It's just me being a baby, but not me being an anticipatory repudiator. If Andrew gives Brian a gift and then Brian promises to give Andrew a gift, there's no consideration to support the promise. So this is the butterfly question. Andrew, you've been such a good friend to me. Here are my butterflies. Thank you, man. I love butterflies. The next day, Brian, I'm so happy you gave me those butterflies. I promised to give you my toolbox. Well, there's no consideration because that wasn't a bargain for exchange, right? Those were two separate gift promises. And then finally, concealment will allow the non-breaching party to avoid the contract. In general, we are not going to reward the bad faith party. In the MBE, if one party acts fraudulently, acts in bad faith, they conceal something, look for the answer that's going to punish them and allow the inflicted party to recover. All right, let's go to torts. Defamation is a statement of fact that is injurious to another person, an opinion that can clearly only be interpreted as an opinion, such as claiming a governor who signs a death warrant is a murderer is not defamation. If it says the only reasonable way to interpret this, governor or murderer was to say that, yeah, he signed a death warrant, so he technically is a murderer, you know what I mean? Then it's an opinion and it's not defamation. Remember, especially if it's a public figure, we need to show actual malice. So knowledge of its falsity. Furthermore, defamation concerning crimes of moral turpitude, loathsome diseases, unchastity in a person's business are slander liable per se and damages are presumed. Before the recording started, we did a lot of good mnemonics. I like mnemonics if they are sharp and they help you. I don't like them if they confuse you. This one, this fits with my whole vibe right here, the club, right? I remember this mnemonic, I know what it means, and I look out for it on test day, and it's helpful. When people are like, Aunt Susie parties on a Thursday to eat vegetables and it means like 17 different things, that might not be the best thing down the stretch. But good mnemonics like club or spaces for, exceptions to the warrants, search into arrest, instant arrest, plain view doctrine, automobile exception, consent, exigent circumstances, and stop and frisk doctrine. Like those are good mnemonics, or my legs or swap, which we'll get to. Like those are good mnemonics. If they're good, they're clear, and you can sharply remember them, then I do encourage you to utilize them down the stretch for sure. So what this means is that damages are presumed. Like you don't have to prove any damages. If you say, Andrew has XYZ or his business is XYZ. If a landlord makes it unusable for a tenant to live there and also engages in behavior that amounts to trespass and worse, he can be found liable for compensatory, injunctive relief, and punitive damages, right? Compensatory relief for the lease, injunctive relief, to stop doing what he's doing, and punitive damages because he's being a real jackass. If one party presents evidence of negligence per se, violation of a statute, by showing the car swerved across the highway, this is prima facie evidence of negligence. However, if the other party presents indisputable evidence in rebuttal that the driver suffered an unforeseeable heart attack, this rebuttal evidence will prevail and the driver will not be found negligent or negligent per se. So just because someone violated a statute and damages occurred doesn't mean that they're going to be found liable for negligence per se. Because they violated the statute and damages were incurred does mean that there's a presumption that they're liable for negligence per se. But yeah, if they had an unforeseeable heart attack, they didn't violate any duty, and therefore they're not going to be found liable. If a pharmacist overprescribes, the pharmacist and the pharmacy can be held liable for negligence. However, this is not a product defects case because the pills were not defective, nor was there improper labeling. There was just negligence in prescribing the pills. So yeah, products defects cases are going to be like from the, producer, manufacturer, distributor, retailer, supplier, not from the user, not from the doctor, not from the dentist, right? This is an overprescription. This is going to be a negligence in overprescription. If it could be criminal negligence if he really OD'd. Okay, for strict liability attached to an abnormally dangerous activity, the injury must occur from the abnormally dangerous activity itself, not something related. For example, if a roof tile flies off a power plant, this is not strict liability. Another example is if someone slips on toxic sludge, this is not strict liability because the injury did not result from the toxicity of the sludge, but from the slipperiness of this. They really test this a lot, where it's like strict liability for toxicness, but it has to be from the toxicity, not the slipperiness. It has to be from the abnormally dangerous condition for you to prevail under strict liability under that theory.
Andrew,
A homeowner,
I have a
what?
really quick question. For strict liability, for example, with wild animals, how could you also be charged with negligence at the same time? Or is that not that common?
I mean, yeah, if you're a personal injury attorney and it's you versus Tommy, you're going to try all of your theories. So first, claim Tommy is liable under theory of strict liability. Judge, in the alternative, Tommy is liable for negligence. Ideally, he's liable for both, right? Like, so they're just alternate claims for damages. So you can always, be liable for negligence and for strict liability. They're just two different theories of recovery.
Okay, thanks.
For sure. A homeowner is liable for battery to an intruder simply because he or she is reasonable for causing the injury by planting an explosive device or spring gun. It's not necessary that he or she specifically intended to harm the intruder. This is a really tough question, but it's like they're just liable because they had the unreasonable thing. It's not because they intended to harm them, right? So like if you have a thing on your door that zaps anyone who steps on it, there's no need to prove intent. It's just like it's foreseeable that someone would step on it and you're going to be held liable, even though they're a unknown trespasser, because it doesn't matter. Like people still trespass and that's foreseeable. Like Jehovah's Witnesses might come on your door. Might be trick or treat, might be Halloween. Res ipsa loquitur means that the thing speaks for itself and injury would not have occurred in the absence of negligence. However, it's also true that the injury causing instrumentality must have been under the exclusive control of the defendant. For example, if a landlord rents out 70 to 72 units and a flower pot falls from a balcony, res ipsa would not apply and the landlord cannot be held liable because negligence can not be shown on his or her part, right? So like again, it's kind of like that, oh, it seems like res ipsa, but the landlord's not an exclusive control. Res ipsa is more like the person who's living there, it's their balcony, or the doctors and the scalpel in the body, right? The danger of barbed wire is apparent and it is a legal, non-deadly use to protect property. The danger of barbed wire is apparent. I had to think about this question, and I just put myself in the real world. And I'm like, yeah, people have barbed wire all the time. Like, just because someone gets injured on it doesn't mean they're liable. It means that the person who, was using the barbed wire is, who got injured climbing the barbed wire is an idiot, right? On Torts has always been my best subject. From the day I remember when I started law school, I got my syllabus and I asked myself, what the fuck is a tort? I'd never heard that word in my whole life. And then when I took the class, this dude, Michael Graham, like, you think I'm a little unhinged. This dude, he would curse us up a storm. He would say shit that was blatantly racist. Like, I would never. Like, he has some issues, but he said some shit that was like valid too about torts, whatever it may have been. I took him for elements too, for evidence too. But anyway, I understood torts because at the end of the day, it clicked with me. It was like he said, there's people like my aunt who believe that anytime someone is injured, someone could be held liable. There's people like me who believe the opposite, that, you're responsible, you stubbed your own damn toe. It's not anyone's fault but your own. But like people like Michael Graham's aunt, Susan, think that there should always be someone held liable. That's why we have so many personal injury attorneys in this world who are running around suing everyone, very litigious, because, they're trying to collect. But at the end of the day, the reason why I've always been so good at torts is because you just step away from the question and think about it in reality and think about common sense and think about reasonableness and be like, if this happened to my brother, like, what the fuck would be this? If my brother was like, yo, Andrew, hey man, I'm gashed up. I want to sue these people. And I'm like, why do you want to sue them? They're like, well, I tried to climb the fence and there was barbed wire and I cut my arm. And I'm like, you're an idiot. You're not going to win the case, right? That's exactly how I ended up getting this answer correct when I did it. It's just like, yeah, barbed wire is apparent. It's a valid use, right? Just when it comes to torts or contracts, even kind of step away from it. When it comes to Civ Pro and Crim Pro, I don't really agree with that or evidence. You just got to actually know the answer because sometimes what you think should happen in real life isn't what will happen because it's procedural. But like on torts, it really is pretty I'd say logical and reasonable. On the MBE assumed joint and several liability, a plaintiff can recover the entire amount from any single defendant. And pure comparative negligence, any plaintiff can recover even if 99% at fault. They tell you these things on the first page, the instruction page, but you guys will probably not even read that. However, the specific question can tell you that this jurisdiction has abolished joint and several liability or has modified comparative negligence, which means that 50% at fault cannot recover, or contributory negligence, common law, any contributions of bar recovery. If joint and several liability is abolished, the plaintiff can only recover the proportional amount from each defendant. Definitely make sure you understand this concept and how to work on these questions because I don't know. I know why, but lawyers hate math, but I love math. Math is my favorite. SAT, I love math because the answer is the answer. 7 times 7 is 49. You can't really like look at it sideways. I like these types of questions too, because you're like, just do the math, 70%. It's joint and several liability. Tommy's 30% at fault. He can recover 70% from any plaintiff because you assume pure comparative negligence, joint and several liability. Makes sense. Trespass of shadows requires actual harm or deprivation of time. For example, a little girl petting a dog is not trespass of shadows, right? There has to be an actual harm or deprivation of time. A 5-year-old girl can form the requisite intent to be liable for a tort, right? You can be liable as a child. You'll be held to the standard of care of a similar child. Even if you sell a house, you can still be liable for negligence. For example, a tile flies off the roof and you should have foreseen the danger when you sold the house. So that one's kind of hard. A sells the house to B and then a tile falls off and the person who's injured sues A and A's like, dude, I don't even live in the house anymore. They can still be held liable because, for that. Same with trespass. They could still be held liable for trespass even if they did it, in the past and aren't doing it anymore. They sold the house, but it was encroaching. The original person was still liable for trespass. The original owner here would still be liable for negligence. An inference of negligence via res ipsa can be defeated with evidence to the contrary. For example, if a car rolls into another car, the person can present evidence that they parked properly, the car was in good condition, and there were juveniles tampering with cars in the neighborhood, right? So it's like, yeah, the car rolled, it's res ipsa. It's like, no, my car was parked. These juveniles, they cut the brakes. Whether a party was negligent or not is typically for the jury to decide if there's an argument for and against negligence. So if you're in doubt, like should A prevail or B prevail, the answer is deny summary judgment and send it to the jury. If you're not sure, it's a question for the jury. If a kid sneaks away from a daycare center and the kid can read and there's a warning on a neighboring lake, the daycare center will not be liable if the kid falls in. The attractive nuisance doctrine cannot be applied against a daycare center because they do not own the lake. So the kid can read, the daycare center didn't do anything wrong, and the kid snuck off, it's not their fault. You got to read the facts. Torts, I know I say, I don't want to make it like sound too easy, but I do think that reasonableness will guide you on torts. Libel is privilege upon invitation. For example, if a person has a prospective employer solicit former employers and a former employer states that thing he believes to be true, this is not libel, right? So look for that situation where they invite the libel because they solicit employer. When you all applied for the Florida bar or Illinois bar, whatever bar, you have to ask your former employers to be like, hey, how was this person? If I'm like, oh, Sam or Safwan, XYZ, then they invited that, right? IIED requires outrageous conduct. Merely broadcasting the news without actual malice does not constitute outrageous conduct. Furthermore, IIED does not require physical harm, only emotional distress. So IIED is outrageous conduct. Merely broadcasting the news without actual malice is not outrageous conduct. And IIED does not require physical harm, only emotional distress. So like trouble sleeping, insomnia, or I guess the same thing, fear of cows, whatever it may be. A company will be held strictly liable for injuries that occur as a result of the toxicity of chemicals or other inherently dangerous aspects, but will not be held strictly liable for all injuries that occur from its products, right? Look for that word, all. They'll be liable for all injuries that occur. No, only ones that occur from the toxicity of it. It's a cheeky little test. Every question is an island, a lot of reading comprehension questions. Make sure that you get those questions right. All right, let's talk about the Constitution. The freedom of expression can be limited if someone joins a subversive group with a specific intent to further that group's illegal activity. So that's, you joined group X to, assassinate Y, then they can limit that. The federal government cannot compel states to enact specific legislation. For example, the federal government cannot require states to enact laws regarding drugs in school zones, even though the drugs would impact commercial activity. The reason is because the Commerce Clause does not allow the U.S. government to compel states to enact legislation, only to regulate the channels, instrumentalities, and economic activities of interstate commerce. These questions are tough. Like if it says Congress requires states to enact the law, we don't like it. If it says Congress is regulating the actual activity, that's probably okay, right? Commercial speech is subject to intermediate scrutiny, substantially related to an important government interest. For example, there can likely be a 30-day non-solicitation window for accident victims under the standard, right? The ambulance chasers, the ones who I said are arguing every theory under the sun. I have a lot of friends who do personal injury, so as you know, I take shots at everyone, even myself. Teachers, we're getting phased out by ChatGPT, we're worthless. All right. The First and 14th Amendment generally do not apply to the hiring decisions of private companies, even if the company is regulated by the state. Right? Private companies, look for the privacy. If state action, ask yourself, if it's not state action, then Ibis Prep, I could hire people based on them being smelly or not. I can choose what I want to do because it's a private company. I mean, virtual, I feel like smelliness wouldn't be a big factor, but we do live tutoring, so that actually is important. Hygiene. Congress has absolute power to regulate federal property, including a national forest designated as a federal property wholly within the state, right? Congress can regulate the federal property, sure. Under the Dormant Commerce Clause, also known as the negative implications of the Commerce Clause, states cannot enact legislation that discriminates against interstate commerce or unduly burdens interstate commerce. For example, a state cannot charge manufacturers different prices from different states. So if it's wholly intrastate, if it's a state just regulating stuff within the state, that's okay. But if it affects interstate commerce, that's going to be problematic. The Privileges and Immunities Clause does not apply to corporations, right? If you catch that on test day, give yourself a yes, oh, they thought they were discriminating against out-of-staters, but it was Nike claiming it, not the right answer, right? You really want to be proud of yourself when you catch things that other people miss. I think that's really going to be the difference maker between a lot of people passing and failing, is like, oh, this is a tough test. The more I teach this test, the more I disagree with the traditional way it's been taught, which is like, la-di-da-di-da, just like pick the best answer. Like, who cares? Just shut up, pick it, you'll be fine. Like, no, look at the answers carefully, consider, everything and choose the right answer, because it's a tough test and there's a lot of exceptions, details, trick questions, reading comprehension things. I really feel like my approach is better of like, treat every question like it's a dying patient and you got 2 minutes to save him, and you're going to do absolutely everything, and you're going to give that question the same attention you would give to a patient whose family members are in the waiting room, hoping that the person's going to make it. Like, really give the question the attention it deserves, instead of just like, randomly picking answers. But again, be very, very cognizant of your time, and make sure every hour you're where you're supposed to be, because there's definitely a balance between overthinking questions and underthinking questions. I think you should just think them through properly. All right. A law prohibiting all forms of picketing except one subject matter would be content-based discrimination, subject to strict scrutiny. What is strict scrutiny? The government must show that the regulation is necessary to achieve a compelling government interest and is narrowly tailored and the least restrictive means possible. For regulation to trigger heightened scrutiny, it must have a discriminatory purpose, not just a discriminatory effect. For example, a law that requires school children to wear shorts below the knees is likely subject to rational basis, even if it affects more girls than boys. It's not the outcome of the legislation, it's the intent of the legislation that would trigger intermediate scrutiny. A public school cannot refuse to allow a group of students to use a room based on the content of their speech, as this would trigger strict scrutiny for content-based restriction. The federal government can require anyone with a fleet of 100 cars to have at least 5 cars electric under the Commerce Clause, right? This right here is Commerce Clause. They're requiring the people to have the cars. This right here is commandeering, because they're requiring states to enact legislation. Now, they can have conditional funding, meaning like, we won't give funding to any state that doesn't raise its drinking age, but we can't force states to raise their drinking age. So they can't compel states, but they can coerce them, if that makes sense. The federal sovereign immunity protects the government from suit for monetary damages, but not for injunctive relief. So look at that. You can sue, the state for injunctive relief, or you can sue an individual in their official capacity. Congress has broad taxing and spending power. So Gabby, we know that album cover view, flexing. I'm going to show everyone album covers next class. So if you haven't submitted your album cover, you got like one more day to do it. The portrayal of sexual intercourse is, okay, I'm sorry. The right to be a candidate is subject to strict scrutiny, right? If you didn't know that, the right to be a candidate is subject to strict scrutiny. Race, alienage, national origin also subject to strict scrutiny. The portrayal of sexual intercourse is protected speech that does not rise to the level of obscenity, right? It's got artistic, literary value. And then alienage, however, so we said alienage is subject to strict scrutiny, but this question is tough. Alienage is subject to rational basis when related to an integral part of government, such as serving on a jury, voting, running for office, being a police officer, or as Safwan tested in the test, and I'll give Safwan credit for this tough question, or being a public school teacher, right? Under, if any of y'all saw the White House, they posted roses are red, violets are blue. If you're illegal, we're coming after you or something. So I feel like you're going to see a lot of this, a lot of like things that would seem like discrimination against aliens, but it's going to be okay because it's going to be related to an integral part of the government. I'm not saying anything about any president. As y'all know, I'm independent. I support my own campaign. All right, real property. Let's do it. Real property. An equitable servitude will not terminate upon the death of the promisor, absent a provision otherwise. Equitable servitude will run with the land if there is notice, intent, and touches and concern the land, right? That's an equitable servitude. The difference between an equitable servitude and a real covenants are remedied by monetary relief. Equitable servitudes are going to be remedied by injunctive relief. In order for a deed to be delivered, there must be present intent. For example, if a person says to nephew that he will deliver a deed in the future, and before that date, the nephew steals the deed and records it, there's never been delivery. That's a common answer. Safiola, I honestly am trying to do this ridiculous task you asked me to do. To be fair, you should ask Sam to do it because you like her more than me, allegedly. But I'm going to try to do it for you, Safiola, which is, come up with, my list of answers I lean towards if I see them. Not saying answers I'm just gonna pick blindly, but I'm just like, if I'm stuck between two answers, better answer choices. It seems to be a good answer choice that the deed was not actually delivered, right? I see that answer coming up a lot. So maybe Sam will add that on her list of Safiola's expert or exceptional requests. All right, a fee simple determinable will automatically revert upon the occurrence of a stated event. For example, a devise that goes to A so long as property is used for church purposes will automatically revert back to A when property is no longer used as a church and will go to A's heirs if deceased. So long as is durational, while for the period of. Durational language will be automatic reversion. Be careful. For the purpose that has no effect. If I devise property to Sean for the purpose of creating a school, he doesn't have to create a school and he can devise it to Susie, right? If I say I devise a property to Sean, so long as he runs a school on the property, that the second he stops running a school would automatically revert to me. Now, subject to condition subsequent would have the right of reversion. The right of reentry, which would mean I give this property to Sean, but if Sean stops using it as a school, then I retain the right to re-enter. That's subject to condition subsequent. So make sure you understand that automatic reversion for determinable durational language, right of reentry for condition subsequent, but if, upon the condition, and then for the purpose that has no legal effect. So if time is of the essence, it is expressly, if time is of the essence, is expressly stated in a land sale contract, then it will be valid otherwise. It will be valid. Otherwise, there's a reasonable time to close after agreed upon date. So, then it will be valid. Otherwise, there will be a reasonable time to close after agreed upon date, meaning that time is not usually of the essence in a land sale contract unless it's explicitly agreed upon, then it is of the essence. For example, if the contract required marketable title, which is implied anyway, and the seller cannot deliver marketable title by a closing date and time was of the essence, the buyer could rescind the contract, for sure. A liquidated damages clause may be upheld in a land sale contract so long as it is reasonable and not a penalty. A deposit, for example, is a typical type of liquidated damage that seller may be able to retain, right? The reason why they may be able to retain it is because it's like, we're gonna have a deal, you pay this this deposit. Now, if you rescind, well, shit, I incurred time and expense, and now I got to relist it, XYZ. So it's like liquidated damages clause, they can't operate as a penalty. They can't be unreasonable, but they are valid in certain circumstances. We saw the one in contracts when it was like, I'm going to take you out on a boat and then you didn't show up. And then I ended up getting someone else, but it was 3 hours later. I didn't make as much money. It was reasonable. Or this scenario where it's like, yeah, now I got to relist the property, XYZ. So liquidated damages clause are calculated ahead of time because damages would be too speculative in light of a breach, but they have to be reasonable in nature and cannot operate as a penalty. So a contribution action, when one tenant makes mortgage payments and can recover pro rata from the other, sure, they can see contribution. Overuse of an easement does not lead to termination. Rather, it calls for injunctive relief or a surcharge. So just because there's a good mnemonic that I saw somewhere for ways that an easement will terminate. I can't remember if anyone knows it, but it's not going to be overuse. It would be like, express agreement or merger or some other things. If there are two competing interests and neither party is protected by the recording statute, the common law rule of first in time, first in right will apply. For example, if two parties are donees, the party who received the property first will prevail and erase notice jurisdiction because the other party did not record and is not a bona fide purchaser, right? Bona fide purchasers are going to cut off prior rights. If there's a dispute between two parties who own equal shares in the property, a partition may be granted and an accounting may be ordered to make sure the costs are divided fairly. So a judicial partition means like, we're gonna sell the property and split the proceeds, or a physical partition could be like, we actually cut the property in half. It's usually hard to do a physical partition, but it is preferred if possible. But they can't do a physical partition if it will make one property unable to conform with zoning requirements. A buyer will be charged with inquiry notice if a reasonable inspection of the property would have provided notice of the interest. For example, if a buyer does not actually know someone is operating a farm on the property, they are still are not a BFP because they will be charged with inquiry notice since they should have known of the use of possession. So someone's operating a farm on the property, even if it wasn't recorded, even if they didn't actually know, they should have known and therefore will not be a BFP because they had inquiry notice. If a mortgagor can buy back a property after a foreclosure sale, this is statutory right redemption, right? After statutory redemption, you get that. Things like this, easy questions, get them right. The right to buy back property before a foreclosure sale is an equitable right of redemption. As long as you know the difference between them, you can get that question right. And then finally, the tenant, not the landlord, is entitled to interest on a security deposit escrow account. Why? Because it would be some bullshit if the landlord could just, pool together all of your deposits and earn interest on it. That would make them like Cash App, PayPal, Venmo. Those are scam companies, I'm sorry to say. Or here's another one. You're going to hate this company I'm not a fan of because I tried their little matcha tea yesterday and it was subpar. Starbucks. Starbucks makes so much money because y'all put money onto their Starbucks gift cards. Then they pool all that money together. Then they invest it in, an interest-bearing account, and they're making a killing off of that. Starbucks can do it. The landlord cannot, right? And the only reason Starbucks can do it is because you sign a little waiver when you sign up for their little thing. So if you guys want to know about the evils of corporate America, I can teach that after March 1st. All right, let's talk about civil procedure. And I'm not trying to hate on Starbucks, but I was not impressed by this little matcha thing I had. I don't understand why kids are drinking coffee at such a young age and then needing Adderall to stay up when they turn of age. I think there's the problems with that. And the biggest thing is their food tastes like prison food. Why are they pumping shit out of like a little ketchup dispenser? Like, can't they get some fresh fruits and fresh juices? I don't know, man. That's my beef with Starbucks. I know I just lost a couple fans out there, but whatever. It is what it is. These are only my opinions. Opinions, not defamation. All right, civil procedure. Merely shifting blame in an answer is not a proper way to implead a third-party defendant. You must actually allege a claim, right? To implead, you have to file a claim. You can't just, shift blame in an answer. Whether a party has to submit to a mental or physical examination is a procedural question. Therefore, in a diversity case, apply federal procedural law when there's a question of whether a party must submit to a mental or physical examination. You could see right from one of my top slides here, right? Whether or not parties are submitted to mental examination, federal law, procedural. Exactly. I'd highly recommend you review this PowerPoint. Under the 7th Amendment, federal claims for money, legal claims, entitle a jury trial. However, claims that are purely equitable in nature, for example, injunctive claim does not entitle a jury trial, right? So 7th Amendment legal relief, so this is federal, not state, although most states have adopted similar constitutional provisions, but still on the test, this is federal, not state. There is a jury trial right to claims at law. Those are, for money over $20. Now, if there's a legal claim and an equitable claim, and they're tied together, there's common issues, you'll get a jury trial for all the claims. If there's legal and equitable claims that are different, you'll do the jury trial first. Even if the what gave rise to the jury came in the counter claim or something later, you always do the jury trial first. That's just a procedural thing because it's like, let's get these people in there, let's get the show on the road, let's get the big thing done first type activity. All right. When there are legal and equitable claims that are connected, there must be a jury trial for all claims. I just said that. It does not matter if a claim is being presented through a class action. You're going to look at the basis of the claim. It's legal in nature. So what's the underlying claim? That's what's going to determine if they get a jury trial or not. When the verdict is inconsistent with the answers to the ultimate jury questions, the court may reverse the verdict and enter judgment for the opposing party. For example, if the jurisdiction recognizes contributory negligence as a complete defense to a claim, and the jury answers yes to whether there was contributory negligence, but still enters a verdict for the party, the court could reverse and enter judgment for the other party. Like, right, this could really happen. I mean, in real life, I don't think this happens that much. Like, it'd be a lot of idiocracy going on, but like on the bar exam, this could happen where they totally give a wrong jury instruction, where they give jury instructions and the verdict doesn't align with the answers. And in fact, not only does it not align, but it totally, bodes well for the other party. They could enter judgment for the other party. If like they say that they recognize contributory negligence as a complete defense, they answer yes that there's contributory negligence, then the defendant's got to win. A party who might be jointly and severally liable for damages is not a required party for federal rules. This is just one of those bright line rules that just, you remember, you can get that question right. Where just because a party might be jointly and severally liable, they're not required for federal rules. Required parties are interesting. Required parties, formerly known as necessary parties, need to be joined to the case. That's called a compulsory joinder. If the court determines the case cannot proceed without the required party, right, in the interest of good conscience and equity, like that, then they are deemed indispensable and the case must be dismissed. So the first determination is if they're required. If they're required, then we have to join them if feasible. But if it's infeasible to join them, then we have to determine if they're indispensable or not. Indispensable means that in good conscience and equity, whether the case can proceed without them, and if it can't, then we have to actually dismiss the case. So that's the kind of concept of joinder, required parties, indispensable parties, etc. A certain 12B defenses must be raised at the first opportunity that are waived. Venue, PJ, process service, and service. Usually this is the answer, but for example, if they file a pre-answer motion, it's waived in the pre-answer motion and cannot be brought in the answer. So like you use it or you lose it, right? That's the 40-year-old virgin quote. A compulsory counterclaim arises. Oh, that's gonna be me soon, man. I'm 35. I'm 5 more years. A compulsory counterclaim arises at the same transaction occurrence, so it is barred if not brought in the original proceeding, right? Compulsory counterclaim, you got to bring it. It arises at the same transaction occurrence. You'll see that same transaction occurrence, common nucleus of operative fact come up a lot. Compulsory counterclaims, supplemental jurisdiction, right? For claim preclusion to apply, adjudication on the merits, involuntary dismissal with prejudice, 2 voluntary dismissals, it must be the same party to their privies in the same configuration. So if A sues B and the case is dismissed with prejudice, it does not preclude B from suing A. We talked about that before the recording started. A complaint cannot be amended to add another party if it is a diversity case, and adding the new party would destroy diversity. Fair enough. Non-mutual issue preclusion is when a non-party to the original case tries to assert issue preclusion, and it's only allowable if the jurisdiction specifically authorizes it, right? We talked about that before the case. If a woman sues an insurance company for proceeds because her husband has been missing for 5 years and she has the burden of proving he is dead, the husband is not dead, he is in Tijuana living la vida loco, or the wife is in Trinidad at Carnival, right? So just know that, like, 5 years, that's not enough. I mean, I don't like this question because there is a presumption about 7 years in federal law that I think most jurisdictions abide by. But the way they test on the MBE is just because someone's been missing for 5 years, we can't assume they're dead for an insurance claim. And then in criminal law, mandatory presumptions on elements of the crime are not permittable. So if we're murder, we have to, bring them the body. A default judgment can be made against a party who fails to plead, respond, or appear unless there's excusable neglect, and there must be facts to support this. If a third party wants to defend a claim to an action that is not a party, it can bring a permissive intervention claim. So I told my boot camp a little bit about intervention, right? If you ever have any family members who suffered with addiction, what do you do to help them? You have an intervention, which means you step in, the third party step in and, tell them to stop doing the drugs or something like that. If a third party wants to bring a claim, it cannot bring permissive intervention. If a third party wants to defend or bring a claim, it can bring a permissive intervention claim, right? Intervention is always going to be permissive. For a federal court to hear a federal questioning claim, the federal law must be in the complaint, not the defense. An anticipated defense using federal law does not grant federal question jurisdiction, right? The federal question has to be in the face of the complaint. Erie only applies in diversity cases, not federal question cases. If federal common law allows non-mutual issue preclusion and the case is subsequently tried in a different state, the court will look to the preclusive effect of the federal common law because it's a federal question case. So if it's federal question, we're only doing federal law for procedural and substantive. If it's diversity, that's when we use Erie to determine if we're going to apply state law for the substantive issues and federal law for the procedural issues. Pretty tough stuff, man. When I do my course, I always hit them with Real Property Civ Pro back to back. I call that the gauntlet, right? The 2 hardest subjects, and they're not easy. Evidence is a little smoother, but evidence is one of those subjects where it's like you kind of confuse yourself the more you study it, because there's like all these things that are like really tough to grasp, but just try to understand hearsay at least. So statements made by co-defendants amongst the other defendant and the attorney are privileged on the attorney-client privilege. A witness may be asked on cross-exam about being afraid, beaten by their spouse to explore a motive not to testify against them. After an accident, if a liable party says, I'd like to give you $100 because I feel so bad about this, this is an exemption as a party opponent admission. It's not an offer to compromise because it's not over a dispute and the declarant has not denied fault, right? There's not an active dispute. It's not disputed. They're just saying it's my fault. That's going to be a party opponent admission. A statement where a woman, this question bothers me. A statement where a woman is claiming that her deceased husband said the defendant told him on the street, I'm going to blow your head off one day, is subject to double hearsay, multiple hearsay analysis. Maybe the inner statement comes in as a present sense impression, intention to do something, but the outer layer, the husband's statement to the wife, is still hearsay, and thus the statement is inadmissible. So, look at hearsay, double hearsay, the outer layer, the inner layer, the he said, she said, and consider if it's an out-of-court statement being proffered into evidence in order to prove the truth of the matter asserted. A record keeper may testify to the absence of public record under the public record absence from public record exception to hearsay, for sure. A person may testify to matters in which they have firsthand knowledge. For instance, if there's a dispute about an amount in a ledger, a witness may testify to remembering larger amounts being deposited into the ledger than the amount currently in the ledger. The best evidence rule does not apply to testimonial evidence. Therefore, it's not necessary to bring in the ledger instead of testimony. In fact, both could probably come in. Right? If they were talking about the ledger and they were like, oh, how much is in the ledger? Let's bring in the ledger. But if they're talking about how much was deposited into the ledger, well, maybe more was deposited than it's on there because someone was siphoning it off, right? In a murder case, the first witness can provide character evidence related to peaceableness, but not truthfulness, because only peaceableness is pertinent to murder. The crime fraud exception to the attorney-client privilege will allow communications between attorneys and clients in the evidence if the communication was in furtherance of committing a crime, such as tax fraud by acting to predate checks, for example, right? Crime fraud exception to the attorney-client privilege. In a criminal case, judicial notice is merely a presumptive inference for the jury, not a requirement. In a criminal case, if judicial notice is required, the jury may, but has discretion, to accept the fact as conclusive. It's must may in criminal. In a civil case, if judicial notice is required, the jury must accept it as conclusive. Must standard in civil. As you all know, I've said this a few times, I've taken the MBE 4 times. I'm going to take the next gen bar in 2026. I might do it in Palau, but probably like Virginia or Oregon or something. But anyway, I've taken the MBE 4 times. 3 times they asked this specific question. So that's one thing that I could say. It's like there's not that every test is different ball game, but similar questions. But this they've tested a lot. So make sure you understand this about judicial notice. Some things the judge will instruct the jury to take judicial notice of. So that means they must take judicial notice, like day on the calendar or something. Now, it's dependent whether it's civil or criminal. If it's civil, if they must take judicial notice, they must accept it as conclusive. If it's criminal, if they must take judicial notice, they may, but are not required to accept it as conclusive. So it's the must standard in civil and the must may standard in criminal. A lot of times look to see the case big. Is it a civil or a criminal case? And that could really impact your answer. It's kind of like, talking about mental elements, mental states that are elements of the crime. You cannot do that in criminal if they're like a psychologist or something, but you could potentially do it in civil. So you got to really orient yourself between civil and criminal and apply different laws. Same thing with this character, right? If character is an issue or is a defense to a claim, specific acts may be substantively admissible. For example, if someone is accused of defamation for calling a person a thief, evidence of that person stealing is admissible to show that they are indeed a thief, because truth is a complete defense of defamation, and if it were true that they stole, then they were really a thief. And there's no successful claim for defamation since it is true that they're a thief, and truth is a complete defense of defamation. I don't know why I said that like so roundabout over and over, but yeah, defamation, sexual assault, things like that, where character is at issue, we are actually going to be able to bring in specific acts substantively. There's a rebuttable presumption that properly stamped and addressed mail is received. However, if this presumption is properly rebutted, then it's up to the jury to decide whether or not the mail was received, and therefore summary judgment or JMOL would not be appropriate. Jurors are allowed to compare handwriting specimens with already authenticated handwriting specimens, right? The jury, if it's already authenticated, we can compare, the jury is allowed to compare. Remember, the jury may become familiar with someone's voice for the purpose of trial, but they may not become familiar with someone's handwriting for the purpose of trial. Only if they had familiarity before the trial can they, talk about that, but not during the trial for handwriting. This they test a lot. The judge determines questions of admissibility, such as qualification of an expert witness, and may consider hearsay without regard to the hearsay rule. I'll tell Sam to put this one on her list for Safiola if she gets around to it. I know she's pretty busy. But the judge determines questions of admissibility, such as qualification of an expert witness, and may consider hearsay without regard to the hearsay rule. So questions of admissibility are for the judge. The weight of the evidence is for the jury. Make sure you understand that concept. If a man answers a questionnaire for routine checkup and states that he had pain in his chest, this is likely admissible for seeking medical attention. Since the statement was made by the man and not by the employer or physician, for example, it cannot be a business record. Distinguish that. If it's the statements made by the person seeking medical attention is probably a statement for medical treatment. If it's made by the physician or the physician's assistant, then it might be a business records exception. A naked offer to pay medical expenses is admissible as an offer to pay medical expenses, but is not a compromise because it does not ask for anything in return or is in dispute refuting blame. So, if they just say, hey, I'll pay your medical expenses, and it's not because I feel bad for that, or then it could be inadmissible as a offer to pay medical expenses, right? Public policy, but it's not a compromise. A compromise has to be in return for something. If you do this, I'll do that. You do me a favor, I'll do you a favor, right? That's a compromise.
One sec, Andrew. Can you explain this one more time? So medical expenses saying, hey, I'm at fault here. I shouldn't have.
No, not hey, I'm at fault here. That's a party opponent admission. Don't say I'm at fault here. Just be like, oh my God, Susie, I'll pay your, just a naked offer, right? Like, here's something that CJ, I think you and I probably have in common. We're gentlemen, right? So if we were in a situation and there was a damsel in distress, we may offer to pay for it, even though we weren't at blame and even though we're not compromising. That naked offer, just like you feel bad, not because you did something wrong, but just because you're a good person type shit, would be inadmissible. That's what that's getting at. And then the compromise has to be some dispute or, you do this, I do that, or you're saying it's this, I'm saying it's that, let's agree on this. A naked offer to pay medical expenses just means like, holy shit, Susie, your arm is chopped off. I'll pay for it, right? Like, just, go to the doctor. I got you, right? That's what that's kind of talking about.
Got it. Thanks.
All right. If a woman is claiming, you see that, CJ? I told y'all he's a gentleman. If a woman is claiming that there was a car malfunction, we can bring in evidence of her intoxication as a possible alternate theory of liability, right? Lady's trying to say, oh, the car malfunctioned. It's like, no, lady, you were drunk. It's a alternative theory of the case. And then the recorded recollection exception. Remember, the statement was accurate when made, but the declarant has no current memory of the statement. That could actually come in, as an exception. We're refreshing the recollection on stand. That's just like, hey, look at this, and then you speak. That could be looked at by the opposing party, but it won't be, read into evidence because it's just a refreshing recollection on stand. So make sure you note some differences between like statement against interest, they must be unavailable, versus party opponent. Recorded recollection versus refreshing their memory on stand. Recorded recollection, they have no memory of it when it was said, it was accurate, and they have no memory of it now. It was accurate when it was said. They're gonna bring that in. We're just refreshing their memory on the stand. That's not gonna come in for any reason. That's just for refreshments. All right, we're getting down to the last subject and then we'll do the review. I appreciate y'all sticking with me. If I'm gonna do something, I'm gonna do it proper. That's kind of how I live my life, right? Merely encouraging a criminal to flee is not aiding and abetting, which is necessary for accomplice liability. People hate this one, but it's like, yeah, just cheering Tommy to get away with the crime isn't criminal accomplice liability, right? But if you drive the getaway car, that is. If you ever saw the last episode of Seinfeld, they got this one wrong, right? They put him in jail for cheering someone to do a crime, which really isn't a crime. But then they brought up all their past transgressions and they turned out they're pretty bad people. They're funny people, but bad people. If a person wants to steal a watch and picks it up to take it, the moment he picks it up, this constitutes larceny. Even if the person who owns the watch comes up and says that he would like to give it to him, right? Once you take something with the intent to deprive and you've taken it, even if you give it back later, even if they give it to you later, whatever it may be, it's instantaneous larceny.
Hey, Andrew,
Yeah.
Quick question, but like I don't know if it was on the test or if it was a previous example, like the dress scenario, but like if you wanted to like, wear the watch to show off for an evening and then give it back like the next day or something, then it wouldn't be larceny because you had an intent to return.
Yeah, exactly. Exactly. As long as you don't have the intent to permanently deprive, it's not larceny. But if you're like, hey, I'm gonna take this watch and then I'm gonna keep it forever, and you're like, you know what, actually, I'll give it back tomorrow. Larceny. Because you had the intent to deprive initially, your later like change of heart is too late in that sense. The crime has been committed. The elements of a crime need to be proven beyond a reasonable doubt by the prosecution. Defenses such as entrapment or insanity or self-defense do not necessarily need to be proved by the prosecution, and they may also be lower standards such as preponderance of the evidence and clear and convincing evidence. Remember, so insanity is not, an element of the crime, and they can even eliminate the insanity offense. There's no constitutional right to insanity defense, nor that it has to be proven by the prosecution, nor that it has to be proven beyond a reasonable doubt. If a person antagonizes another person to kill someone, they can be found guilty of murder via theory of recklessness, but not transfer intent because they didn't have the intent to kill someone directly, but to goad someone into committing murder. I only use this word goad because one of my students used the word goad. I just know my lexicon. I would never use that word goad. What does that even mean? To goad someone, to like encourage someone to, yeah, we'll just use goad. We like goad. I never call myself the goad. All right. What is the next question? Something about goading, right? Goad, okay. Under the model penal code, conspiracy can be unilateral, meaning one party can be found guilty of conspiracy, even if the other party was an undercover cop, etc. Under the common law, conspiracy requires bilateral activity, so a person cannot be found guilty for conspiring with an undercover cop. So make sure you understand this distinction. Honestly, I would expect it to be opposite, but it is what it is. So model penal code is unilateral, right? There's a model trend towards snitchery, and the common law is that it needed to be bilateral. If the police had an arrest warrant for a woman and they arrive at her house and it's clear that she is not there, it's boarded up, the grass isn't mowed, the neighbors say she's literally not there, they cannot break in and search the house and find a gun, for example, because they have no reason to believe she's there, right? It's an arrest warrant. You have to have probable cause that they're there. You can't just break into a boarded up building and do a search for an arrest warrant. That would make no sense. Unless you really thought she was living in the boarded up building, right? A person cannot be convicted of larceny and robbery because larceny is a lesser included offense. It has all the same elements. A distinction between false pretenses and larceny and robbery is the voluntariness of the transaction. Larceny is stolen where robbery is with force. False pretenses is with deception, but voluntary trait. Factual impossibility is not a defense to attempt. If a person believes a substance is cocaine and attempts to sell it, this is an attempted distribution of drugs. However, if the original supplier knew the cocaine was actually sugar, right, booger sugar, he cannot be convicted of attempt to distribute because he did not have the intent to sell cocaine, but to sell sugar. That was like a joke from my earliest previous administration. I kept saying sugar booger, and then one of my students hit me up and they're like, I think you mean booger sugar. And I was like, oh, you're right. But I like to say sugar booger. It sounds funnier. If a statute states that the crime must be done knowing that they have no privilege to do so, and someone does the crime believing they are privileged by judicial decree or attorney advice, they cannot be found guilty because they do not have the mens rea to commit the crime. So a lot of these questions will give you like, this is what defines the crime. That has to be knowing, and the fact show it wasn't knowing. Well, they didn't have the mens rea, the mental state, the culpable mind. A police officer may order both the driver and the passenger out of the car during a lawful stop. Some of y'all hate that, but that is the facts. Like I said, on torts, I lead with reasonableness and what would be best if my aunt was in this situation or my sister. On crim law, crim pro, I tend to side with the police officers. My heart wants to side with the criminal and let him get away, but I don't know why. I just seem to like, I'm not saying it's like 80-20, it's maybe like 55-45, but it seems to be more of like, no, they can do this, right? Like, no, the police officer is allowed to ask the passenger just to get out. That's just a trend I've noticed, but don't take that for too much. Maybe Sam can elaborate on it. If an officer has subjective motivation to pull someone over, they suspect them of being a drug dealer or their ex-girlfriend, is okay as long as there's a legitimate reason to pull them over. Going 68 in a 65, for example, right? This is like a pre-contextual stop. It's like, as long as you pulled him over for a legitimate reason, it's okay. If there was no reason to pull him over and you just pulled him over because you wanted to, or you were racist or whatever, that's problematic. But if they were going 66 and 65 and you're a cop who's in the Klan and you just wanted to pull him over because of his race, technically the cop can do that because you were going 65, 66 and a 65, right? If a woman sees a dude with a bomb and about to blow up the function and fails to warn anyone, it's not criminal behavior and she cannot be convicted with any crime, right? There's no duty to save the day. I would think that I would like to do that, but this lady didn't want it and she's not a criminal. A person cannot be later convicted of felony murder, even if the victim later dies, if they've been acquitted of the underlying felony charge. This was a really tough one. I think we actually got this wrong as a class, except for Heather and Gabby, I remember. For example, if someone is acquitted of rape, but the person who was allegedly raped later dies, the defendant cannot be retried for murder under violation of double jeopardy. The reasoning here was because the rape, remember, burglary, arson, rape, robbery, kidnapping, the rape was the underlying felony, and if they've been acquitted of the underlying felony, then they can't be later convicted of the felony murder. Now, this differs from a question where it's like, you know, Tommy is convicted of burglary, and then 6 months later, the person who we burglarized dies. Now he's going to be convicted of manslaughter. That could be possible because it's different elements. The death didn't happen, yada yada. That's different than this one particular question where it was about underlying felony for murder. If someone finds a wallet with money and decides to keep it instead of return it, this constitutes larceny, right? They found it. Oh, shit, I'll keep it. Larceny. There's no reasonable expectation of privacy when your neighbors have a vantage point of your marijuana crops. They grow a lot of marijuana and they do a lot of cocaine on the MBE. Just be ready for that. They murder a lot of people. They're all high. They're all murderous. And it's just absolute mayhem. Like it's hard to do the MBE because the fact patterns, if you really think about them, are gut wrenching, right? The big, a 4-year-old is like raped and killed, and you know, civil procedure question about like summary judgment. It's like, what the fuck, you know? So it's a tough test to stomach. I understand that. I'm trying to help you all, you know, be most prepared for it. All right, finally, all subjects, todos los sujetos. If a person tried to poison her husband to death, but she doesn't take a sip of the drink, this is still attempted murder because the requisite steps have been taken toward attempt. If the maid drinks the poison glass that the husband set aside, the wife can be convicted of murder, right, depraved heart, or at least involuntary manslaughter, criminal negligence. I did this question with a student earlier today, and she said, come on, wife, you got to finish the job, you know? You go there to murder your husband, and he gives you, you know, a little kiss, you got to murder him anyway, right? The plan, you got to stick with the plan, lady. You had a reason why you wanted to murder him. You just got, you know, Tinder swindled in the moment. You got to stick with the plan, lady. That's what this student said. I don't believe in murder. I'm peace, love, and happiness. The state may not force a private club to include members who oppose the club's sincere mission. This is the Boy Scout case, right? So the state may not force a private club to include members who oppose the club's sincere mission. If you're trying to join the Boy Scouts, but you hate Boy Scoutery, then, you know, they can refuse your admission. Children doing adult-like activities will be held to adult-like standard of care. For instance, a dumb kid driving a car. An amateur skier who caused an accident will be held to a standard of care as an ordinarily prudent skier, not an ordinarily prudent amateur skier. An expert skier will be held to a standard of care as an ordinarily prudent expert skier. You do not get a reduced standard of care for sucking at something, but you do get a heightened standard of care for being expert. This is coming from my personal test-taking experience. I always tell people, it's been said in this industry, shut up and pick it, right? I could not shut up and pick this question. I stared at it for 5 minutes and I was just like, it was hard for me to get over. I don't recommend that. I recommend shutting up and picking it, you know, just getting through it. Try to allocate the same time to every question. No question should hemorrhage your later success, but this happened to me and I got it wrong because I went on Google right after and I was wrong about it. So I'm teaching this all as a lesson. You do not get a lower standard of care, but you do get a heightened standard of care. There was another time where I took the test and I Googled it right after and I got it right, which was the principal in the school only needs a reasonable suspicion to do the search, not probable cause. The police officers need probable cause, and if the police officer is using the principal to do the search, they need probable cause. But if it's just the principal on his own volition and accord, it's only reasonable suspicion in a public school. All right, under the doctrine of estoppel by deed, if a party conveys property that they do not own but later inherit or receive the ability to convey the property, the earlier conveyance is prevented from being denied. So A knows it's going to receive Blackacre by mommy's will. A conveys Blackacre to girlfriend to impress her. See, no one has a problem when I say the word mommy, but now I can't say the word daddy. I've learned, like, even right, like what? Y'all have problems. A conveys Blackacre's girlfriend to impress her. So A knows he's going to get in mommy's will. A conveys Blackacre's girlfriend to impress her. Mommy dies. So now A receives in the will. Girlfriend breaks up with A. I'm sorry, A, but that's what girls do, right? When you're at your lowest and mommy dies, that's when girls and friends breaks up with you. But first, girlfriend had to secure the bag and get the property, right? A wants to convey land to the new crush, but A will be stopped from denying the earlier conveyance. The girlfriend owns Blackacre. So girlfriend did what girlfriends do, right? Girlfriend tricked boyfriend into conveying the property. Girlfriend waited till mommy died. Girlfriend now broke up with boyfriend and keeps the property. And this is why girls run the world, right? It's called estoppel by deed. All right. If a federal statute permits jury trials for plaintiffs, be very careful to read the question and see if a defendant moving for a jury trial is they cannot do so under the statute. This is a really tough question where it's like a statute permits plaintiffs for jury trials in these cases, but the defendant was moving for it. They do that a lot. They'll be like, you know, only defendants can remove, and it'll be a plaintiff trying to remove. They try and throw a curveball at you and switch up the party that you're expecting to do the action. So just be very careful that, you know, you understand what's going on in the fact pattern and if it's allowable on its face. The 7th Amendment guarantees the right to a trial by jury at civil cases and federal court for cases at law, monetary relief, also for cases that were triable by jury at common law, such as writ of ejectment. So that's the 7th Amendment right to jury trial for legal relief and for cases that are triable at common law. Writ of ejectment is a good one that you could remember. If it's for writ of ejectment, they do get a jury trial, even though it's injunctive. A bill of attainder is a legislative act that inflicts punishment without trial, right? In a pure comparative negligence jurisdiction, a plaintiff who has any amount of fault, even 99%, can still recover damages, which would be the complete amount of damages reduced by their percentage of fault. If a party can prove that the court lacks minimum context in a pre-entry motion, the case should be dismissed for lack of PJ, right? They don't have minimum context, there's no PJ. The market participant rule, and these are two heavily tested ones. The market participant rule is an exception to the Dormant Commerce Clause. So if the state owns and operates an oil field, it does not have to comply with the Dormant Commerce Clause, which prohibits discrimination against interstate commerce. Another heavily tested exception to the Dormant Commerce Clause is that the federal government, Congress, expressly authorizes the state to enact the legislation that would otherwise violate the Dormant Commerce Clause. In a race notice jurisdiction, a BFP who records will cut off any rights to any previous interest holder, and a subsequent donee will take upstream shelter in the status of the BFP. So make sure you understand race jurisdiction, first to record, notice jurisdiction, the subsequent BFP, or race notice jurisdiction, the first BFP to record, or the last BFP to record first, however you want to look at it. If a woman hires a hitman to kill someone, and the hitman goes to kill the guy, but the guy trips and falls on a rock and dies, and then the hitman shoots the guy in the chest, the woman cannot go down for murder because the hitman did not actually kill the guy was already dead. The woman could go down for attempted murder because she took substantial steps toward the murder and had the requisite intent. So attempted murder, like even if it was impossible to do it, if you tried to do the murder or tried to sell the drug that wasn't even cocaine, it's still going to be attempt. But the actual, crime of distribution or the actual crime of murder, you won't be guilty of because you didn't actually do it. So attempt is easier to be found guilty of than whatever it is, the completed crime. To prevail on a First Amendment claim that a law is discriminating against free exercise of religion, the plaintiffs must show that the law is aimed at suppressing the religious beliefs, right? Not just has the effect. In order for a court to exercise PJ of a party, they must have minimum contacts. Merely owning a property in a state but having never visited there will not satisfy the requirement. Maybe they could have quasi in rem jurisdiction if it's like about the property or something like that, but not just because you own a property there. An as-is clause is a valid disclaimer to disclose defects. So if a property is sold with an as-is clause and a warranty deed is delivered, and there turns out weeks later to be termites, they cannot sue for breach of contract or failure to disclose because it was sold as is. Firing shots into the air with even no intention to kill someone constitutes depraved heart murder because it's devoid of social utility and it's an act of an individual with a depraved heart, right? Warning shot death, shooting guns, even with no intention to kill, was going to be depraved heart murder for sure. A new trial should be granted if the, I mean, the only time shooting a gun wouldn't be depraved heart murder would be like if it was voluntary manslaughter, adequate provocation. If you walked in on the pool boy with your husband or wife and pulled out your gun and shot him, well, yeah, there's using a gun. It's not depraved heart, but that's because it's been reduced to voluntary manslaughter. That's probably been.
Does the same apply if you're in like an abandoned area, like in the forest, opposed to like in a city?
No.
Depraved
mean-
heart, it's basically like if it's reasonable that you could assume that someone's present. Like the presence of people is what differentiates between depraved heart murder and involuntary manslaughter. So like involuntary manslaughter is like you didn't expect anyone objectively.
Like if you dropped a rock off a building near a highway, that's the depraved heart. But if you dropped a rock off of a bridge over water, that would be involuntary manslaughter.
Yeah, like if you did it like at like 3 a.m.
Okay.
and it's like a boat showed up, it's like
Exactly.
who would drive a boat at that time?
It's the reckless indifference towards human life. Like, yeah, if I throw a rock off a building, it's 3 a.m. and I'm sure no one's going to be down there. That's not reckless indifference towards human life. And I'm like, oh, people down there, when I think of depraved heart murder, I think of like the Joker, the new Joker, where the dude's just like laughing, cracking up maniacally. Like, that's depraved heart murder. You're just not even thinking anything. Your example of like in the woods shooting a gun, I mean, you're hunting. Like, you don't think there's going to be people out there. That's way different. You got to look at the recklessness of the act itself. Think of shooting a gun into a playground or shooting a warning shot. Like if you don't, depraved heart. Okay. A new trial should be granted. The jury would likely be biased by repetitive derogatory comments, and manifest justice would result. For example, if an attorney calls a defendant no good meanie face and the judge tells him to stop and he does it again on closing, this could be reason for a new trial. That's kind of a reading comp question. In order to prevail under strict liability relating to injury caused by toxic chemicals, the injury must result in toxicity, not just a slippery of it. For example, we've done that one a lot. Y'all better get that one right on test day, right? A reading of a license plate number as a car speeds away is likely admissible as a present sense impression. Additionally, if the person who made the statement accurately recorded on the pocket dictation device and currently has no memory of its contents, it may also be admitted as a recorded recollection, right? So it can come in both ways. The president may validly make executive agreements with foreign nations that prevail over state law. Remember, the hierarchy is going to be constitution and then federal law and treatises, and then executive agreements, and then state law. The business record exception to hearsay requires that notes are made in the ordinary course of business, right? Not like in anticipation of litigation. A proper foundation must be laid for past recollection recorded, which is he currently has no memory of its contents. It was accurate when made, and it was made at the time of the scene. A government employee has First Amendment rights of freedom of speech. They can speak on matters of public concern, but they can be held responsible with discharge, for example, if they communicate an unwillingness to perform their jobs or responsibilities. This was a question about the guy who walked through the slums and he's like, I'm not even going to do the investigative reports on this people. They wouldn't, they're no good slum people, right? It's like, well, dude, your job is to do the investigative reports. And if you say you're not going to do it, then that's not going to be protected by the freedom of speech. Dog barking are not statements and they cannot be considered hearsay. Neither is machine readings like a radar detector, right? Hearsay's got to be a statement. A government program that gives discretion for awarding loans based on strength of applicants is valid. There's no right to notice and hearing for those denied the loan, right? Like you were denied the loan for a reason. You don't get notice and hearing because you didn't get it. A validly qualified expert witness may make, sometimes I can't spell, opinions based on his or her specialized training and expertise and experience. Sure. Joint several liabilities at default run to MBE if a party is the but for cause of an injury, even if the injury was totally result of negligence and there are contributing tortfeasors, the plaintiff can recover the full amount from the defendant, obviously minus their contribution. The difference between larceny by trick and false pretenses is larceny by trick, the perpetrator obtains possession, whereas false pretenses, the perpetrator obtains title. Asking a friend for money with the intent to pay him back, but later losing the money on the parlay is not false pretenses or larceny by trick because there's no concurrent intent to deprive and false assertions or statements, right? There had to be concurrent, falsity, not like later you decided to keep it. A person can be compelled to incriminate themselves despite the Fifth Amendment protections if they receive use and derivative use immunity. Transactional immunity does not need to be provided. So not immunity for all crimes, but immunity for crimes that are related to, you know, this testimony, right? That's going to be like, hey, I plead the fifth, fine. We're still going to make you say what you're going to say. We're going to compel you, but we're going to give you use and derivative use immunity. So look for that answer for sure. Use and derivative use immunity versus transactional immunity. Use and derivative use immunity is protection from the crime. Transactional use is protection from prosecution for any crimes. Remember, be very wary for these any, all, must, these absolute answers. You know, sometimes they're correct, but you should look at them kind of skeptically. If a man's accused of arson, both evidence obtaining duplicate insurance for motive and threatening to kill the ex-wife for testifying consciousness of guilt are both admissible as mimic exceptions to the general rule that specific acts are inadmissible to show propensity or conformity. So motive, intent, mistake or lack of mistake, identity, common scheme or plan, or consciousness of guilt. The risk of loss passes to buyer when the goods are delivered to a common carrier under a shipment contract, right? When they're delivered to a common carrier under a shipment contract, if it's free on board destination, then it's when it arrives at the destination city. An assignee of a contract is an intended beneficiary. You can assert rights under the contract. So that's a good thing. Think of an assignee as an intended beneficiary. And then finally, the difference between an assignment and delegation is that an assignment is of rights, the right to get paid, for example, and a delegation is of duties, the obligations to perform, for example. So we're going to do one more, review on Sunday from 11 to 1, where we'll do all subjects and we'll add to this. And then I'll put it on the master cram guide and make our master cram guide even more masterful. And, you know, that's kind of the last thing that I would look at before the exam is the master cram guide. I would read it from top to bottom, recognizing that that's the cram guide that's been made over the past 4 administrations from my students doing live questions. And I think that you'll see a lot of these concepts replay themselves on test day. I really appreciate everyone. We took a whole hour extra. I told you were going to get your money's worth, which is a joke because this was a free extra session. But I really like to make sure that we leave no stone unturned and people feel prepared for test day. On Thursday, we'll, play the game at the beginning that we played today, the Wheel of Life game, where I'll get some participation from the class, and then we'll go over the questionnaires. And then finally, like I said, on Sunday, we'll do live practice questions again. Hopefully we'll get them all right, and we'll end the program with confidence, and I'll send you all on your merry way. So I want to thank everyone for joining me tonight. I'm going to go ahead and stop this recording.